Hi, everyone, and welcome back to The Break, PIA series on hot topics of insurance. We're still kind of going through the last of the COVID-19 related topics. So today we'll talk about EPLI and COVID-19. Here to actually go into detail about about the subject is our Director of Government Affairs, Brad Lachut, and I'll just turn over to Brad.
Thank you very much, Claire. So as Claire mentioned, we're going to be talking about EPLI insurance and COVID-19. It's been a topic that we've been getting more and more questions on as more employers are bringing employees back into the office, and some are still working remotely, which presents its own unique issues with EPLI. So we'll get into, let me get in it, what does an EPLI policy cover, generally speaking, some common exclusions that we need to be aware of that are going to restrict coverage in some areas that are going to be likely with COVID issues, and then some best practices to avoid claims. We're going to do this all in hopefully, 10 minutes or less. So first things first here, EPLI policies, just as an overview of what they are. Employment Practices Liability Insurance, EPLI, covers businesses against claims by workers that their legal rights as employees of the company have been violated. In essence, in lay terms, it protects employers from their employees, in other words. And it covers a broad range of topics, such as discrimination, wrongful termination, retaliation, and wage and hour issues. Now, at the onset, let me acknowledge this is a generalization right here. And there are many more claims that are covered by these sort of policies. However, generally, those claims are a subset of the ones that I just mentioned. For example, sexual harassment is a form of discrimination, so it would be considered a discrimination claim, even though sexual harassment would be covered under it as well. So again, these are more of the broad overview as opposed to everything that an EPLI policy covers. In addition, and this is a big in addition here, there's no standard EPLI policy, and coverage terms, conditions, and exclusions can vary considerably. So it is very important to review these policies with your client to ensure that they have the coverage that they think they have. This leads to an actual separate point more globally on EPLI. A huge issue with EPLI claims is that employers think they have coverage for this sort of stuff, but they don't. Obviously, there's what I just mentioned. They might have a policy that excludes something they think is included, but even a bigger issue is many employers don't have EPLI policies at all because they think they have that employer coverage under a separate insurance policy. So a BOP or a CGL or something like that, they do not usually. So they might be under this false assumption that there's coverage, and then they're going to get sued, and they're going to have a rude awakening, and hopefully your agency is not contacted for an E&O suit. So be aware that there's a big misconception as to what EPLI policies cover and what other policies coverage provide, if that makes sense. So with that, let me talk quickly about the exclusions. There are a couple common exclusions that are generally in all EPLI policies, or not in all EPLI policies. First, bodily injury exclusion. Bodily injury claims are typically excluded under these policies, although those exclusions usually contain exclusion within themselves, an exception for emotional distress and mental anguish. So bodily injury would not be covered, but mental anguish related to bodily injury would be covered. This leads to the classic legal kind of distinction between claims for bodily injury versus claims arising out of bodily injury. Sounds very similar, but they're different. One you'd have coverage on, arising out of a bodily injury, such as mental anguish, but you would not have coverage for bodily injury. So in other words, if somebody was to contract COVID at work and they were able to prove it, they likely would not get any cover, or you, the employer, would not have any coverage for the damages related to the bodily injury. However, if the employee claimed mental anguish that's related to COVID-19, that policy might respond and provide coverage for that. Again, it's kind of in this minutia of what is and what is not covered. In addition to bodily injury, OSHA and FMLA violations are generally not covered by these policies. That's obviously a big one, because if we're dealing with COVID-19 issues, a likely claim is going to be that an employer did not follow guidelines to make sure that their workplace was safe, or they might have denied an FMLI leave request when they shouldn't have. So the fact that these are excluded is a big issue, because again, these are going to be reoccurring issues or common issues under these sort of policies. given what we're living in right now. In addition, wage and hour. I just mentioned wage and hour as a covered claim. Now I'm mentioning it again as exclusion. And this goes back to what I mentioned, how there's no real standard in EPLI policies. There is going to be a variety of different coverages for wage and hour. Some policies are not going to provide coverage at all. Some will provide coverage for defense costs and any fines. Some will provide complete coverage. So you're talking about defense costs, any sort of fines, and also paying back wages if that's something that happens. So there's a lot of variability there. That's why I included under both coverages and exclusions. So be aware of that when you're discussing this with your clients. Wage and hour is a big area that an employer can get tripped up, especially when we're talking about telework. And I'll talk about more of that in detail in a second. And then finally, the WARN Act. Now this applies to larger employers. This requires companies with 100 employees or more to provide 60 days advance notice to employees affected by mass layoffs, which is defined as terminating 50 or more employees. WARN Act violations are specifically excluded by most EPLI policies. So again, if you have a client who is a larger employer, again, 100 or more employees, they need to follow this if they're going through any sort of mass termination. So be aware of that. That they, one, they need to follow it, and two, that it's not going to be covered if they don't follow it. Which leads us to the next topic here, best practices. As we all know, the best claim is the one that doesn't occur. So how do we avoid these sort of claims? First, we'll talk about the OSHA and the FMLI issues. As I mentioned, those are generally excluded. However, that does not mean there's not going to be any coverage at all. Well, these sort of policies will not cover a claim that an employer did not meet OSHA guidelines. Those exclusions typically have a carve-out for related retaliation claims, such as an allegation that an employee was impermissibly laid off after exercising OSHA or FMLI rights, or an employer took some sort of adverse employment action, even if it's not a termination. So if a vacation request was denied, or they were relegated to the night shift, that would be considered retaliation. You would have coverage under an EPLI. That's not to say that an employer should do that. Please don't, by the way. Just saying that there would be coverage for that sort of thing, even though the root cause is an OSHA violation. Likely it's going to be some sort of termination, perhaps an employee saying, I don't want to come into work because you're not providing face masks to employees, so I'm not going to, and then the employer says, okay, you're fired. That would be considered retaliation, again, coverage under the policy, but still a messy situation. Related to that, many employers have started to implement waivers. They're having employees sign waivers saying, if I contract COVID-19 at work, I'm not going to hold you liable. I would not rely on those. Honestly, I probably wouldn't even use them. Generally speaking, many courts will find those sort of waivers unenforceable as against public policy. That is especially true if you have an employer who is relying on the waiver instead of doing what they should be doing and providing a safe workplace. So if you have an employer saying, well, I'm not going to provide masks or keep people 6 feet apart because I've got this waiver, it's not going to work that way. A court's going to throw that out in about 3 seconds. So employers should not rely on waiver as their sole defense against COVID-19 claims. They really need to make sure that they're following the guidelines that they're following, that it's going to help for a variety of reasons. But again, the waivers are not very good. They might give you some peace of mind, but it's a false peace of mind. Switching over to the topic of wage and hour, inconsistencies, again, in the amount of coverage that I hear lead to issues. When we're having telework, it is increasingly difficult to make sure you're accurately tracking employee hours. One of the benefits of telework, right, is it gives flexibility to workers to work non-traditional hours. Maybe the office is 9 to 5 and an employer has to take care of a child at home, so they're working at nights now. They're clocking in at 7 and working until sometime in the morning. That is great that the flexibility exists, but it makes it more difficult for the employer to track hours and to make sure that people aren't going over 40, or if they are going over 40, that they're compensated with overtime. So what employers should be doing is they should be implementing a telework policy. that policy should clearly spell out when the expected hours are for a company, 9 to 5, whatever it might be. If employees need to deviate from that, they should get written permission from a supervisor saying that I'm going to be working 7 p.m. to 5 a.m. or whatever. In addition, employers need to closely monitor the hours that are worked to ensure that people aren't going over or that they're adhering to that schedule. And if somebody is going over, they should also get authorization for that too, saying, okay, I need to go to 45 hours this week, get everything done. Make sure they get prior authorization from a supervisor. One additional note here is an employer can never withhold pay from an employee. So that is not a solution. If an employee works over 40 hours, is entitled to overtime, they must be paid. They can be disciplined after that, but the discipline cannot be withholding the pay. It's not going to work that way. You're going to end up in front of a court, and they're going to require the employer to pay the claim or pay the wages and probably pay a hefty fine too. So it's not worth it in the long run. For those large employers, again, 100 or more, the WARN Act, make sure that you're providing the adequate notice. That's 60 days notice of any sort of mass layoff. This would include temporary furloughs as well. So if you're going through that, maybe they've already done it, or maybe they're going forward, they're saying, the profits aren't coming back like we thought they would. We're going to have to terminate employees. Make sure that they're following the WARN Act, or else they're going to get in trouble. They're going to get fined. It's not going to be a good situation. And then finally, when it comes to discrimination, it's important to note that digital discrimination is still discrimination. Just because it's not occurring in the workplace for telework doesn't mean it's not occurring, and it doesn't mean it's not workplace discrimination. Those working at home, their home office is an extension of the employer's office. So harassing emails, text messages, things like that is still harassment, still discrimination, can still lead to a workplace discrimination claim. So employers should make sure that they are following their discrimination policy if they get a complaint, whether that stems from an in-office incident or a remote one. All complaints should be taken seriously, investigated the same way, regardless of where they occurred. So again, that was pretty quick hitting stuff. With that, if anybody has any questions, they can certainly email myself or Claire, as well as the Resource Center. And now I'll turn it back to Claire to see if she has any questions. If not, we'll conclude, and hopefully this was informative.
I guess just before we wrap up, a quick clarifying question with specifically a lot of the questions we've come in have had to do with COVID and basically what happens if an employee gets COVID, and for EPLI purposes, what's the likelihood of a claim there? I guess just clarifying how COVID or other illnesses really could effectively lead to an EPLI claim or not.
So if I'm understanding the question correctly, there's one thing I didn't mention here that kind of goes unstated, and maybe it should be stated, and I'll state it right now, is that it's very difficult for an employee to prove they contracted COVID-19 at work. We're seeing legislation now that creates presumptions, right? And there's a reason that they're doing that, is because it's very hard to prove where you contracted any sort of illness, especially something like COVID-19 that is very infectious and is widespread. So it's easy to say, well, that person got it at the grocery store as opposed to at work. So that is probably the biggest defense that an employer would have, is that it's very difficult for an employee to prove they had COVID-19 at work. Now, what I mentioned earlier, an easy way for an employee to get around that is to show that an employer is not following the safety protocols. No masks, no social distancing, things like that. Very quickly, a court or a jury is going to look at that and say, yeah, they probably contracted it at work, as opposed to the grocery store that's actually adhering to all the guidelines they should be adhering to. So that leads to the importance of adhering to these guidelines, because one, and most importantly, it keeps everybody safe, but two, it's the best way to escape liability.
All right, great, thanks. With that being said, we'll have another video shortly about the workers' comp and the presumption Brad was talking about. So how the COVID plays into that side of the insurance world.
Perfect. So. Thank you, Claire. And thank you, everybody. Hopefully this was informative, and we'll see everybody soon.